Down to judicial matters, where a River State High Court sitting in Port Harcourt has issued an interim injunction against the Speaker of the State House of Assembly, Martin Amawule, and 32 others, including the Clerk of the Assembly and the Chief Judge. The court barred the Chief Judge, Justice Simeon Chibuzo Amadi, from receiving or acting on any request or documents linked to an impeachment move against the governor and his deputy for 7 days. Justice F.A. Fubara gave the order while ruling on ex-parte motions filed separately by Governor Siminalayi Fubara and his deputy, Professor Ngozi Maudu. The judge also approved substituted service of court papers on the lawmakers at the Assembly quarters and on the Chief Judge through staff at his chambers within the High Court premises. And to further help us understand this, we have a lawyer, Towo Oseruwoja. Good afternoon, Mr. Oseruwoja. Can you tell us how much of the impeachment move against Governor Fubara is driven by genuine governance concerns, and how much is rooted in the deepening political rift that we've been seeing, of course, between him and his predecessor, Nyesom Wike?
Okay, good afternoon, Queen. Let me first of all go into the first question. Is the issue is how rooted is the procedure? The question should be, well, the procedure is going in line with Section 188 of the Constitution. Then if it's rooted on governance, that is a question of what do the people of Rivers State want? The representative reflects the attitude and the quality of the people of Rivers State they represent. And if you look at what is on the public domain, you will discover that it's more of personal interest rather than the general interest of the people of Rivers State. And if the people of Rivers State decide to keep quiet, obviously we have what we call the express consent and we have what we call the implied consent. So it's the difference between the members of the State House of Assembly, the governor, and the key actor, the FCT minister, and the people of Rivers State, including the elders, the traditional rulers, and even the people on the streets of Rivers State, is just an issue of opportunity. Because I know, as a matter of fact, if it has to do with good governance, if it has to do with interest of institution in developed nation, I think that Rivers State there will be consistent protests, peaceful protests of people that want a good governance to replay. Then if you get into the link of the political crisis between Nyesom Wike and Fubara, you now come to the point where you now ask yourself that in an insane society, abnormalities become abnormal. So a good example is that if you look at the speech and the gesture of the FCT minister and what is playing now, and you see the media, side of the media are sympathetic to both sides rather than being objective. Obviously, abnormality has become normal in our society. So there's no need to question whether what he's saying or what is happening is a normal thing in a society. The question should be a bone of contention with sympathy to what is within the public domain is an agreement. What is the agreement? Yes, an agreement can be entered generally, which is the general provision of the law, and parties are bound by the agreement. But when that agreement goes contrary to public interest or is illegal, such agreement, even if entered, is null and void, and any of the party at any given time can stay out of it. So, and now boils down to the judiciary. This is where the judiciary comes to play. And you know, in a political setting where the judiciary becomes political, obviously anarchy and uncertainty of the law becomes the order of the day.
So what does this court injunction really mean legally? Does it completely stop the impeachment process or merely pause it temporarily?
Well, if you look at the provision of the Constitution, particularly if you look at the impeachment process, Section 188 of the Constitution, there are 8 stages of the process. So from what I could see and what I've read and what I've heard from a close source of either of the party by privilege of getting to know one person that knows somebody that knows somebody, you discover that they are the 3rd stage of the process now, out of the 8th stage. So now the court has stopped the process, and which by every known judicial precedent or known law is that irrespective of the order of the court, being wrong or right, all parties are bound to respect such an order. And it's an ex parte process. So even if you as Queen is in court and I bring an ex parte motion before a judge against you, if you are in court, you have no right to say anything because the substantive issue is to protect an interest. So the substantive issue is what will happen. So that ex parte that has been made is a temporary measure. Is a temporary measure that puts a pause to the proceedings of the impeachment. So it's not temporarily, it does not temporarily close, it does not permanently close that process. So let's see how it unveils.
So Towo, can a state high court legitimately restrain the House of Assembly and the chief judge in an impeachment process? Or does this raise serious constitutional and jurisdictional concerns? What do you think?
If you listen, okay, Queen, if you listen to my first statement, I said when the judiciary becomes political, do you understand? The law becomes uncertain and anarchy is said to be let loose. We have the three arms of government, which is the powerful of them, or is the legislative arm. They talk about the executive, we talk about the judiciary. They work independently. And impeachment processes in all clearly spelled out by the Constitution of the Federal Republic of Nigeria cannot be stopped by a court order. But if you look at the statement I made earlier, is the fact that if an order of court is gotten right or wrong, all parties must respect the order of the court for the purpose of sanctity. Then this is where the society comes in. Now, this is where institution comes in. Like in the UK, I'll tell you as a matter of fact, there are some certain things legal practitioners engage in Nigeria. If they try it, even think of it, they will lose their license. So, and what comes in now? The legal practitioner disciplinary committee comes in. The lawyers who file that process. What is the information before them? The judge, because we are surprised that though it's practicable that a case can be filed today, it can be assigned today, and it can be heard today. It's practicable. It's something that is practicable. It cannot be influenced. It's a process, because when you look at it, if it's as urgent as possible to protect interest and to protect societal peace, the judge can sit even in chamber to grant such an order. But another thing again is exercising discretion, which cannot be questioned based on what is before the judge. Majority of us have not seen the document attached would have made the judge emphasize or express that distance. But it's a temporary measure, and I believe with time, the process will be put right. But the question will now be, are there several other applications that would have of necessity be heard at that judicious time that was used is something else. But if you look at it, with the judgment we are getting for even the appeals court, some of us, we get to understand the term when they say judge, the beauty of the law is the dynamics. It changes as the time goes. It changes in line with the society.
Yes. So well, we see that, coming from Rivers State, there are layers of different situations happening every day. And I feel like a lot of people are just waiting for the day this will come to an end and for peace to reign. And I just want to ask you, to what extent do you think this Fubara-Wike fallout is going to reshape loyalty and power dynamics within Rivers State House of Assembly?
Yeah, the issue of Rivers State, if you are thinking one of either your platform or one of the media platform, when I made a statement regarding to Rivers State, is something we all need to study categorically, because from 1999 down to our current democracy we are enjoying, with the exception of this current democracy, Rivers State has a way of shaping the political terrain and the legal proceedings when it comes to the wills and the rights of the people, when it comes to the election and who they make. Then I've also made it clear that, and I also spoke to someone who I know is close to the FCT minister. I said the best thing I want to advise him as a person is the fact that I'll recommend a very simple and explicit novel for him to read, which is The Things Fall Apart. And he should carefully study the character of Okonkwo, which I believe is trading that part. Then for Fubara again, I think it's something we all need to look as a level of leadership. Loyalty is something, but when loyalty gets to a point whereby the interest of generality is at stake, the loyalty will put to question. But another thing again, I will also look at the ability of Fubara to influence. Because as a governor, and first attempt, second attempt, third attempt, you are not able as a leader. That means there is a communication gap. There is an information breach. Because I know, as a matter of fact, as a leader, if the people, the House of Assembly members, they don't work in isolation, you would have been able to influence that level. But in all, if you notice what is going on in Rivers State, it will come to an end. But another thing again, somebody will definitely get hurt. Somebody will definitely get hurt. And the somebody is generic, is the people of Rivers State. But docilence is now an act of compromise of the people, because they compromise there. So I don't see the people of Rivers State as victims. I see them as partners in this political crisis now.
Well, thank you so much, Towo Osaruwoja. It's always a pleasure having to have conversations with you and, you know, get insights from the lawyer's point of view on situations. We appreciate you joining us.
You're welcome, Queen.